to our first story of the day. The Presidential Election Petitions Tribunal this past week began deliberating on petitions by several opposition candidates challenging INEC's declaration of Bola Ahmed Tinubu as winner of the February 25th presidential election. It's the beginning of a case that could offer up high-stakes drama. With Action Alliance withdrawing its petition and the court adjourning Peter Obi's petition to Wednesday, May the 17th. PDP's Atiku Abubakar also wants the tribunal to approve live telecast of court proceedings. Arise correspondent Godfrey Eshemoge reports.
Security was beefed up at the headquarters of the Court of Appeal, which is the Presidential Election Petition Court, as nearby road intersections were cut off to traffic to ward off potential threat to security. Thorough checks were carried out on all vehicles that accessed the premises. The court was packed full with senior advocates and other lawyers fully present to represent their clients. Justice Haruna Tamani, in his welcome speech, urged counsels to shun all conduct that could amount to avoidable waste of time of the court, while pleading for maximum cooperation as he assures of commitment to hear and determine all petitions on their merit. The first activity of the 5-member panel was to strike out the petition of the Action Alliance AA after its withdrawal. Factional chairman of the party, Adeleke Rufai, said the petition was against INEC's mode of conduct of the polls and not against Tinubu's victory, and that the proposed policies of the president-elect resonate with what the party leadership holds dear.
This petition was in the main an attempt to bring INEC back to appreciate that no matter how powerful they are, they cannot disobey court orders. About 8 judgments told INEC that this man standing beside me is the national chairman of the party and not any other person. 2 federal high courts told INEC that they must deal with the list he submits and upload them as candidates in the election. INEC ignored all the orders, including the orders of the Court of Appeal, which said the man you are dealing with is not even a member of the party.
One of the reasons advanced by some of our leaders as well is the belief in the ability of Asiwaju Bola Ahmed Tinubu, being a proponent of restructuring, which has been one major reason why we have the barrage of agitation in our land today. We evolved a kind of policy that could engender resurgence of trust in our togetherness as a national entity. Truth be told, our country, Nigeria today, is at the precipice. We need a personality that believes in policies that can repose trust in the aggrieved indigenous nationalities.
Following that, there were pre-hearing sessions for the Action People's Party, APP, which says it will not withdraw its petition, and that by Peter Obi's Labour Party, with the court fixing Wednesday 10th May for continuation. The pre-hearing for the People's Democratic Party, PDP, holds Tuesday.
I am a lawyer. I have the consent of my clients, however it is. So if going forward they give me an instruction, I will take the instruction. But as of today, we are going on and we are strongly coming back on the 10th of May. That's Wednesday, for the continuation of the pre-hearing session.
One way or the other, I do not think that it will be business as usual as far as Nigeria's electoral jurisprudence is concerned. And we have assured the court that we will do all that we can to ensure that these petitions are heard expeditiously.
On our part, all the lawyers for all the parties also committed themselves to cooperating with the tribunal, the court, to make sure that these matters are dealt with urgently because of their national importance. So we are very happy today 3 petitions have been dealt with and 2 to come up tomorrow, and the very important ones, Atiku and PDP petition will be coming up.
The pre-hearing session for the Allied People's Movement APM also holds on Tuesday as the Presidential Election Petition Court tidies up the documents before it as it gets clarity on the number of witnesses and exhibits that will be tendered for the petition proceedings when it gets fully underway. Godfrey Eshemoge, Arise News.
Away from presidential petitions, there was celebration at Government House Osogbo, the Osun state capital, this week, after the Supreme Court upheld the election of Adeleke of the People's Democratic Party as governor. It was a unanimous judgment and effectively sealed the defeat of former Governor Boyega Oyetola and his All Progressives Congress Party. The federal government of Nigeria has told state governments to either build and manage their correctional facilities or pay the cost of keeping their inmates and facilities built by the central government. Minister of Interior Rauf Aregbesola said though the justice system clearly differentiates between states and federal offenders, the federal government has been the only one in charge of custodial facilities and has been bearing the burden of financing them. The minister said the federal government could no longer be responsible for correctional management of state offenders and called on state governments to build and manage their own custodial facilities as empowered in the newly amended Nigerian Correctional Service Act of 2019. Former chairman of the Nigerian Bar Association Ikeja branch and former first national vice president of the Nigerian Bar Association, Monday Ubani, who is now chairman of SPIDEL, joins us now. Thank you for joining us, Monday Ubani. You're welcome to this Live Sunday Talk Show.
Dr. Ruben. Thank you for having me.
Well, very quickly.
Welcome back from Abuja.
Yes, I saw you in Abuja, yes. Well, good events, yeah. But quickly, let me ask you. The Presidential Election Petition Tribunal has now started sitting. Many Nigerians expressed concern about the delay. Took them, the tribunal quite some time to begin proceedings. Why that? After the various parties to the matter at hand had met the 21 days deadline for the filing of petitions. Nigerians would also like to know this whole issue about why is it difficult for Nigeria to determine election petitions, resolve them, before anybody is sworn in at any level, from presidency to governorship to the legislature, because that seems to be the big issue. Some people are saying, look, Section 285, sub 5, sub 6 of the Constitution is what it is. And that anybody, whether it's Agbakoba or anyone else, say, look, these matters can be resolved in 7 days, is just engaging wishful thinking. But what do you think?
Yeah, thank you. I want to start by saying that it's not true that there was so much delay after the cases were filed by the councils of the various petitioners. I think you are hearing me very loud and clear.
Yes, yes, clearly.
Okay, fine. Remember there was an application for inspection of document of INEC before now. And so even before this particular pre-hearing session, there has been a proceeding by this tribunal where orders were made for the parties to have all the documents from INEC to inspect it and to collect all the certified true copies from the umpire. So proceedings are already commenced. Of course, after all the processes, there must be some paperwork to be done by the secretarial staff in order now to commence proper proceeding, which has commenced last week. The pre-trial session has commenced, and this is a very important aspect of the proceedings, where all interlocutory applications are taken. Now, the application for a televised hearing, I think that one is adjourned for next week, and there were so many other applications that are being filed by parties, including primary objections, even by the respondents and all that. These are at the interlocutory stage where all these have to be decided by the court. And at this time also, the court now will schedule the witnesses, how many minutes will be given to each of the witnesses. He will also schedule the issue of admissibility of document. Those non-contentious documents, how they will be admitted, even when trial commences. This is the level at which these things are ironed out. And then the commitment of all the parties sought by the presiding justices in order to ensure that the lawyers cooperate with the tribunal, not to cause unnecessary delay, because all eyes on the judiciary now in order to ensure a judicious dispensation of these cases that have been filed, and in an expeditious manner also. And so they have to seek the consent of all the parties for cooperation, which I know that all the lawyers have given to the justices at the last hearing, that they will cooperate with the court and not cause any delay. So this is a very important stage. Now, with the second question as to why don't you conclude the trial in 7 days, I doubt the possibility of that. If you look at the section of the Constitution you cited, 285, it gives you the timeline within these cases are to be disposed of at the trial, and then at the appellate court, that is the Supreme Court. You have 180 days within which to finish the process. It does not mean that the court have to exhaust all the 180 days, but because of the fact that that timeline is there, and then 60 days for Supreme Court, you cannot in any way now say that the man who has been elected should not be sworn in, because the legal framework has not in any way provided for that. Maybe we have to go back now and look at our constitutional provision and say, look, since this is part of the electoral process, I'm talking about a judicial intervention, it's part of the electoral process. You have had the registration, you have the voting, you have the announcement, and now we are at the judicial sector in order to determine the finality of this process. Why don't we exhaust all before any of those candidates are sworn in? That has been the argument of every other person. But before now, from 1999, the framework, the legal framework has never in any way made such a provision that we have to conclude before we can swear in. Now that this argument is coming up, maybe the National Assembly members will have to look at it, and if there is wisdom that we must conclude the entire electoral process, even with the judicial process, before we can swear in, maybe they can amend the law in order to accommodate that. But for now, the provision of the law is that you can still swear in those who have been declared winner, who have collected what we call certificate of return. Why the court processes will have to be exhausted. 180 days at the trial, then 60 days at the Supreme Court level. So that is the position of the law for now. And unless we change that law, anyone making any suggestion that they should not be sworn in until all these are exhausted will actually be doing what we call wishful thinking. There's no law backing it up.
Okay, I get your point. But there are even some counsel, some lawyers, who are saying that even the 180 days plus 60 days will not be enough. Because for you to file a case, particularly in governorship issues and presidential issues, you have to have maybe 250,000 witness claims. And that, in fact, it has to be extended further. What do you think? Where do you stand in the matter? Are you saying we go the Kenya direction, although in Kenya they have just about 44 million people and their constitution is different from ours? In Nigeria, we used to do election petitions, sui generis, for 3 years. Now, even people are now complaining about 180 days plus 60. What do you recommend beyond constitutional amendment? And if you insist on constitutional amendment, what should that amendment be?
I think those who are arguing that 180 days is not enough may have made that argument when we were operating the Electoral Act of 2010. If you remember that it was manual way we used to conduct our election. But now BVAS, and then the electronic transmission of result has actually reduced all that process. And the new act itself has also made it possible that you can now bring these documents from INEC and then tender that particular document through either one person. You don't need to go and bring all the witnesses at the whole polling unit, which was the initial requirement, which was the usual requirement, that for you to succeed in your petition, you must get all the witnesses at the polling unit to come and give evidence. The new act has now dispensed with that in the amendment that has been done. So you don't need to go and bring all the witnesses now from the polling unit. One witness who is competent enough can have the document of INEC, the certified true copy, and tender it, and it will be accepted by the court. And so I don't think any person at this juncture is still making that argument that 180 days is not enough. in the light of what the law has actually made by removing all that requirement of having all the witnesses come from all over the country in order to come and tender evidence in court.
Okay, the argument is about the sufficiency of the time frames stipulated even in the Constitution and the Electoral Act 2022. But let me ask you about the decision in Osun, gubernatorial election. The Supreme Court, just a few days ago, upheld the ruling of the Court of Appeal in the matter, supporting the importance of BVAS, of the voters register, and from EC8A. Now, what in your view is the implication of that ruling for the presidential election petition? Because some people are now saying that the Supreme Court in the Osun gubernatorial electoral matter has already settled the matter and provided a way forward for subsequent decisions in the presidential election petition matter before the Court of Appeal.
Yes, I won't delve into the depth of what is going on presently, but we'll talk about what has been decided by the Supreme Court. In Osun's case, that particular judgment, reinforces the fact that BVAS has changed the game in our electoral process. There is no question of you relying on the voters' register when you are talking about overvoting. The proper instrument to rely upon now when you are talking of overvoting is the BVAS. You look at the number of those who have been accredited to vote, and then look at the form or the result sheet where all the results are displayed, and look at the number of people who have voted. If the number of those who have now voted, which are recorded in the result sheet, exceed the number of those who were accredited in the BVAS, that means there is overvoting. Let me give you an instance. If 100 persons got accredited in a polling unit, and then you now look at the form where the results are listed, you now see that it is 180 persons that actually voted, showing how the results are distributed to all the political parties. That is clearly overvoting because 100 accredited. There is no way you can have 180. We don't have to have a result now to the voters register. The proper instrument you now use to determine whether that is overvoting is BVAS. It's the primary source of evidence. And that is what the Supreme Court tried to affirm in that particular judgment. That BVAS now is a game changer. If you are talking of overvoting, then look at BVAS. Then look at the result that has been listed and you determine whether there has been an overvoting. That is actually what has happened. So it is a very clear-cut decision. Now let me also say this. The facts of each case determines how the court will get to its judgment. Every fact is very peculiar. If it doesn't fit the fact, it don't just bring BVAS and then throw it in and say BVAS now will solve all the problem. No. It is the facts of the case that determines what the court will do at every time a matter comes before it. What was an issue was the issue of overvoting. And then you don't make use of BVAS in order to prove that point. And the Supreme Court said no. And the Court of Appeal, you have to look at BVAS. How many accredited? How many voted? If there is no such comparison, then you cannot talk about overvoting. That is what that particular decision has established.
Okay, well, thank you for your insights. But let me ask you another important development that has legal implications. The Minister of the Ministry of Interior holding a conference just a few days ago. About the same time we were, at that event in Abuja. Now coming out with the outcome that going forward.
That's right.
That going forward, state governments will have to feed their own inmates, particularly, persons who have been convicted under state offenses. After all, the amendment of the the Correctional Services Act now says, look, state governments can build their own correctional facilities, take care of their inmates. So is this just about giving teeth to the law as amended? Is this about federalism? Do the states have the capacity to build prisons, take care of their own inmates, given the fact that many of these states cannot even pay salaries? Is the minister right? Is he enforcing or insisting on the law? What do you think?
Yeah, thank you. You said in the initial introduction that I was part of that particular program, and I was there when the minister made that pronouncement. But a day to that particular date that pronouncement was made, I was part of the committee that participated in looking at this particular new act. I mean, the amendment, the Fifth Amendment that is the president himself has signed into law that allows state now to participate in issue of correctional center in owning and building and managing, which is a very good thing. I will advise the minister. I listened to him clearly. He's a very good minister, and I love what he's doing, even at the twilight of his administration, where he now wants to decongest the prison. It's a very good program, and we are in support of it. Spidel, MBS Spidel is in support, and I want to thank Power that organized that program alongside with the Ministry of Interior in order to ensure that we participate practically in decongesting our prisons. But in doing that, I will want the minister to take it a bit easy, and then what I mean by that is that this particular amendment was just made. And the states we are not in the position to manage the correctional center before now. Now, nobody was trying to do a differentiation whether you belong to the state or whether you belong to the federal. Anyone that commits crime, both federal law and state law, were all clamped into prison in the various states where those prisons are situated. Now that is a law, now authorizing the state now to enact a law to manage their own prison, to own and manage it. That has to be a phase. It's not something that will be automatic. The federal government has to engage the state in discussion, and then all the modalities have to be worked out, because to manage prison or correctional center is not a day's job. It involves a lot, apart from food, issue of retraining, skill acquisition, and making them to come out into the society to become responsible is key. You don't just say only food you give to them. No, there are other issues. So managing a correctional center is not going to be easy. So the states now have known now that there is a law that gives them that power to do that. So the management process the transition program, the process has to be gradual. They have to enter into discussion and agree how this will be sorted out. I would like it to be done in such a hurried manner where the state now, you don't do this, then we throw out your prisoners in this and that. That will be inhuman. Nobody is going to allow that. The international community will not even support Nigeria for throwing away prisoners, or suffering them. So I think that the states have to enter into a very grave discussion with the federal government as to how this law will be implemented. It has to be done in phases. If it's going to be management jointly, the states have to be contributing money. When the states now want to build their own outrightly, the way it's done in America, fine. Where all those who are criminalized and convicted under state law will now be put in the correctional center, manned and owned by the state. But for now, because this is a new law that has just been made, there has to be a discussion, and it must be done in a phase. And the minister must take it, easy with the states, so that these things can be ironed out in a manner that will be very amicably settled. So that at the end of the day, those prisoners will not in any way be thrown out or made to suffer any dehumanization or inhuman treatment as a result of the fact that a law has been made giving the state the power now to manage their prison. So I am saying, in effect, I agree with him that a new law has been made now. That is what we've been clamoring for, that the state must be given power to do certain things, just like what Godswill Akpabio did even in Akwa Ibom, where he built a correctional center even when there was no law. He showed that the states were willing to do all that all this while. So now that a law has been made, it has to be done in a phase, so that gradually the state now will begin to take care of those who are convicted under the state laws and manage them and take care of them, while the federal laws now will take care of those who have been convicted under the federal law and put in federal prison. That is what I would suggest, not be done in such a hurry that those people who are the prisoner now will begin to suffer. No, I don't think that will be the intention of the minister.
Well, I would like to thank you very much, Monday Ubani, former chairman, NBA, Nigerian Bar Association, Ikeja branch here in Lagos, former second vice president of the Nigerian Bar Association, current chairman of Spidel, the section on public interest and development law of the Nigerian Bar Association.